Hello, my name is Shana Carter, and I help people prepare for tomorrow before tomorrow gets here by preparing their estate planning documents such as wills, trusts, advance directives for healthcare, as well as financial power of attorneys. And I thank you guys for joining today's webinar. And if you have any questions, I ask that you just put your questions in the chat or reserve those questions for the end of the presentation, and I will be happy to answer those questions for you. So I'm now going to share my screen with you. Okay, so estate planning 101. Here are the topics that we will cover. What is an estate plan? What documents make an estate plan? When and why you should review your estate plan? What happens if you pass without a plan? Who makes those decisions for you without a plan? So what you can expect is to gain knowledge on estate planning and how you can use it to protect your family and your assets today. So let's talk about what happens if you pass without a will. Well, if you pass without a will, or if you pass without a valid will, you are considered to have passed intestate. So if you pass without a will or a trust in Georgia, the state does have a plan for you. Unfortunately, it may not be a plan that you like. In Georgia, we follow the rules of intestate succession when someone passes without a will. This is the order of priority in which your heirs, your family members, will receive your property under Georgia law. If you pass with children but no spouse, then your children will inherit everything. If you pass with a spouse and no descendants, then your spouse inherits everything. If you pass with a spouse and descendants, then your spouse and your children will equally share the intestate property, but the spouse's share may not be less than 1/3 of the total intestate property. An intestate property is any property, both personal and real, that is not exempt from probate. So if you pass with parents, but no spouse or descendants, then your parents inherit everything. If you pass with siblings, but no spouse or descendants or parents, then your siblings will inherit everything. So let me give you a hypothetical situation. I want you to meet Martin and Elizabeth. They are Georgia residents. Martin is married to Elizabeth, and they have 3 children who are now adults. Martin and Elizabeth own a house in joint tenancy with rights of survivorship. Elizabeth is also the named beneficiary of Martin's retirement account. Martin dies unexpectedly in a car accident. He never took the time to make a will or any type of estate plan. Elizabeth automatically inherits their home and any remaining retirement funds, as those things are not subject to probate because they owned the house together as joint tenants, and she was listed as the beneficiary on the retirement account. Well, Martin also owned other property that is valued at $300,000. He did not share ownership in that property with anyone else, and he never made arrangements or written decisions as to how that property should be transferred at his passing. So, under the rules of intestacy, Elizabeth will inherit 1/3 of that property, which is equal to $100,000. And the 3 adult children will split the remaining $200,000. According to Elizabeth, this is not what she and Martin discussed. She says they discussed that she would take ownership of everything. Unfortunately, the state of Georgia does not know or have a way of confirming Martin's discussion with Elizabeth because he didn't have an estate plan and had to act according to the rules of intestacy. If you have minor children and you pass or become incapacitated and there's no will or document stating who will become the minor child's legal guardian, the court will appoint one. The court usually chooses a close relative, or a family friend can ask the court to appoint them instead. But why would you leave it to chance when you can nominate someone of your own choosing today? Only assets that pass through probate are affected by intestate succession laws. And some examples of assets that are exempt from probate by their very nature would be property, both real and personal, that you have properly transferred into a trust. Life insurance proceeds with a named beneficiary. Make sure that beneficiary is not a minor, because if they are a minor, you will need to establish a trust for the minor. Then you have funds that are in an IRA or a 401k or any other retirement account with a named beneficiary. Again, make sure the beneficiary is not a minor. Real estate that you own or share an interest in with someone else, depending specifically on how that property is owned and recorded. So whether it's a tenancy in common, a joint tenancy with right of survivorship, or any other tenancy that's recognized here in Georgia, but it'll depend on the ownership that is recorded, because tenancy in common own properties with multiple owners. If one owner dies, the interest does not automatically go to the remaining owners. It stays in the decedent's estate. And if they didn't have a will, well, it's going to pass to their heirs through the rules of intestate succession. Any jointly owned bank accounts or bank accounts that list a beneficiary are also exempt from probate. What is an estate plan? Well, it is a plan it is your plan, and it's unique for you, that reflects your wishes if something happens to you when you are on vacation. And what I mean by that is, say you're out of the country and you need someone that you trust to go to the bank for you to do something that you cannot do remotely. If you have a power of attorney in place, I would allow that person to act on your behalf at your direct authority to handle whatever you need them to do because of that power of attorney. Another example is if you're a parent and your child is away at college and they're out of state and they need you to do something on their behalf, but you're not necessarily on their accounts, the power of attorney would allow you to easily step in and carry out the wishes of your child as outlined in the power of attorney. And you're limited to the power specifically outlined in that power of attorney. So if you ever become unable to participate in a meaningful way in making any decisions about your finances or your health, well, a power of attorney for your finances or an advance directive for healthcare would allow you to make decisions for both your health and your finances. And so what it is that your agent will have this document that they can use as a go-by to make sure that your wishes are carried out while you are still alive, but just simply unable to make those decisions for yourself. Sometimes the healthcare directive is known as the living will, and that's because back in 2007, that's what it used to be called. However, in 2007, the state of Georgia wanted to simplify everything, and they wanted to encompass everything as far as healthcare into one document to make it easier for your family and for your medical providers. So let's talk about what a solid estate plan includes. It includes a will or a trust, depending specifically on you and your unique situation as to whether a will or a trust is better for you. Then it includes a power of attorney, and then your healthcare directive or your healthcare power of attorney, however you want to call it. And that is what you need to have an essentially to have a good, solid estate plan. And if you have minor children, you'll want to have any nominations for guardianship. If you take care of any adults, any elderly parents or anything that matter, you would want to nominate conservators. So let's talk about what is a will. A will is a legal document that expresses your last wishes as to your property, both real and personal, and it allows you to nominate guardians for your minor children. So to make a will valid in the state of Georgia, the testator, which is the person that is making the last will and testament, must have the capacity to mentally express their wishes. The will must be written, it must be signed by the testator, and there must be 2 non-beneficiary witnesses that sign the document as well after they witness the testator's signature. The will must be made freely and voluntarily. No one can force you to make the will. You're choosing to do so of your own volition. A will does not have to be notarized, but the notarization can help speed up the probate process. It should also be known or noted, rather, that Georgia does not recognize holographic wills. And a holographic will is a will that is written but not signed by 2 witnesses. Okay. You should also take note of the fact that as of January 1st, 2021, Georgia adopted a new law that now allows you to easily distribute tangible personal property through a memo or other writing if, 1, your will refers to a possible personal property memo or other document, and number 2, the memo or the writing must be signed and dated by you, the testator, and the document must describe each piece of personal property and the intended beneficiary with reasonable certainty. Your homework tonight is to think about, 1, who do you want to be your executor? This can be a family member, a beneficiary of the will, a friend, but most importantly, this needs to be someone you trust to carry out your final wishes. And that may be an accountant, an attorney that you trust. So then number 2, you are to determine who your beneficiaries will be. Then you need to determine what are your assets and who are you going to leave them to? Who is going to get which beneficiary will take this particular asset upon your passing? If you have any pets, you need to determine who's going to take care of your pet. If you have minor children, you really need to think about who you want to take care of and raise your children if you aren't around or are unable to do so. Who will handle the money for your children? Because you can set up a guardian to take care of the kids, and then you can set up someone else to handle their finances. And what about your grandchildren? You need to determine who is going to act as the guardian of anything that you leave behind for your grandchildren. So let's talk now about a trust. So a trust, so there's the testamentary trust that you can plan for in your will, and that is set up or established after you pass. And then there's the living trust that is established while you are alive. A trust, in a nutshell, is a fiduciary relationship in which one party, the grantor, gives a second party the right to hold title to property or assets for the benefit of a third party known as the beneficiary. So you, the grantor, are giving a trust. Think of it as think of the trust itself as an entity. And you're giving that trust the right to hold the title to property or assets for a beneficiary. Trusts are commonly used to transfer assets to beneficiaries without having to go through the probate process. But in order for that to work, a trust must be funded. And what I mean by that is your assets must be transferred into the trust. Otherwise, they are still subject to probate. Trust can reduce estate taxes and gift taxes. Revocable trust is a living trust that can be altered during the grantor's lifetime, whereas an irrevocable trust cannot be altered after the trust is created. The main reason people choose an irrevocable trust over a revocable trust is if they want to transfer assets out of their taxable estate. And as of 2023, the federal estate tax applies to assets over $12.92 million. That means that you can inherit up to $12.92 million, and there would be no income tax on that inheritance. To learn more about that, I suggest you talk to a financial planner. And if you have one, I would be happy to work with them on helping you to craft an estate plan based on their recommendations for you and your situation. So here in Georgia, we do not have an estate tax as of July 1st, 2014. Again, to learn more about this, talk to a financial planner that you trust, and you can learn more from them about the Georgia estate tax rules. Other types of trusts that you may have heard of or you may not have heard of are the tax shelter trust or the credit shelter trust, the special needs trust, and the life insurance trust. And there's a few more as well. So the tax shelter trust is used by wealthy individuals to legally maximize their estate tax exemption. So this is a great tool for someone who has assets over the 12.92 million that I just mentioned. And then the special needs trust is to supplement if the beneficiary receives SSI or Medicaid benefits to ensure that their benefits are not impacted by an inheritance. Then you have the charitable trust. The charitable trust is a type of irrevocable trust established for charitable purposes. And again, some wealthy people will use this as a way to not only reduce their estate tax value, but also to leave behind a trust for a charity that they care about. An irrevocable life insurance trust is another way to reduce the value of your estate, and it provides creditor protection in some states. However, in Georgia, a irrevocable life insurance trust is not necessary because the full value of that life insurance policy is exempt from creditors. Advance directive for healthcare is the thing that we're going to talk about next. We did briefly go over that earlier, but let's talk about it a little bit more. So like I said before, it's known as a living will previously, and you'll still hear people refer to it as that from time to time. And what you should know is that they're talking about the advance directive for healthcare. So everyone 18 or over needs this regardless of their marital status or whether they have children. Why do you need it? It's so that you can outline what you would want to happen in regards to your medical decisions in the event you're unable to do so yourself. So your homework is to think about what you want for your healthcare directive, like what do you want people to do as far as your medical needs, and who do you trust to actually follow your wishes on that. The power of attorney, we discussed that as well. And so that's another document that every adult 18 and older needs. Parents, if you have college age students going off to college, they need this. And I don't know if I mentioned this earlier or not, but the power of attorney takes effect either on the date that you sign it, if that's what you want and intend, or it can take effect on another date certain. However, the power of attorney loses its power at your passing. So whoever you nominate or delegate to be your agent can no longer make any financial decisions on your behalf once you are deceased. So your homework is to think about who you trust to serve as a potential agent for you. If you have minor children, again, it is very important to nominate guardians now before you need them so that this document's already in place so that you can make the decision as to who raises your kids and takes care of them in the event you're unable to do so for any reason. So do you know these people? It's Abraham Lincoln, Prince, the musician, DMX, the musician and the actor. What do they all have in common? Well, they all passed without a will. President Abraham Lincoln passed without a will, so a close family friend had to serve as the administrator of his estate. And that's the same thing as an executor, but it's a different title when a person passes without a will versus with a will. Well, Lincoln may have wanted to leave his estate solely to his wife, but he didn't take the time to make a plan for the future. So his estate was split between his wife and his two sons. Thankfully for his family, it took less than 3 years to settle his estate, but proper planning could have saved the family even more time and heartache of having to deal with this even after his death. Okay, let's talk about Prince. So Prince, his estate was worth 156 million, and it took 6 years after his death to settle his estate. There was an ongoing court battle. He had 6 half siblings that were named as his legal heirs. He had no spouse or living children. They could not agree on a distribution plan, so they were in and out of court. Okay, let's talk about Mr. DMX. DMX passed without a will. He left behind a fiance and a 6-year-old child. Well, because they were not married, she does not benefit from the intestacy laws, and she has no standing to inherit anything that they did not own together. She did petition the New York court to be considered his common law wife in hopes to administer his estate, but that petition was denied, and the court ended up appointing his ex-wife and his 3 oldest sons as temporary administrators of his estate. If you're here in Georgia or wherever in the world, I'm sure you remember that the rapper Takeoff passed last year, and he passed without a will. And as we discussed earlier, if you die without a will and you have no spouse and no descendants, it goes to your parents. Well, if you've been paying attention to it in the news, you know that his parents are currently fighting over his $26 million estate. And if you are familiar with his music, you know that he raps about being raised by a single mother. One more example for you guys is Game of Thrones. Spoiler alert. If you watch House of the Dragon, if you haven't seen it, stop here or fast forward a little bit because you don't want to hear this. But in one episode, the king is on his deathbed trying to say, I want my daughter to be queen. But his wife, as you know, her stepmom and her childhood friend did not agree, nor did she honor his wishes. And she did the exact opposite. She named their son to be king. That is why it's important to have a will or some type of way to have your wishes written down so that no one can come and say, well, no, she said this or he said this. But he could have written it down and signed it. But again, here in Georgia, that would be considered a holographic will, and Georgia does not recognize holographic wills. So my takeaway for you all today is to have a will, and at the very least, have a power of attorney in place, both financial and medical power of attorneys. And if you have any minor children, please make sure you nominate guardians at the very least. And once you do create a will, you should review it yourself every year to make sure it's up to date and continues to accurately reflect your wishes. And if you have any major life events after your will is created, update it. And when I say major life events, I mean marriage, divorce, the birth of a child, the adoption of a child. If a beneficiary of yours that is listed in your will passes away, you're going to want to update your will. And if you move to another state, update your will. I also recommend that you review your will every 2 to 3 years with an attorney to make sure that no laws have changed in regards to your will. Thank you all for attending today's webinar. Here's my information. If you'd like to book an appointment to discuss your estate planning needs, you can go onto my website and you can book that appointment. If you would like for me to cover another topic, you can leave it in the comments. You can follow us on social media. On Facebook, it is the S.C. Law, LLC. On Instagram, it is at attorney Shana Carter. On TikTok, it is at attorney Shana. And on YouTube, it is also at attorney Shana. Again, my name is Shana Carter, and I help people prepare for tomorrow before tomorrow gets here by preparing their estate planning documents. And I want to say thank you all for attending and watching this. If you're now watching it on YouTube or on Facebook, thank you for watching. And if you would like me to cover another topic as it regards to estate planning, I'm happy to do so. Leave me a comment, send me a message, and I will get back to you as to that. And I hope you guys enjoy your day.